Hello friends, I am Dr. Pawandeep Kaur from Khalsa College of Law, Amritsar. The topic of our today's discussion is History of Writs. Dear learners, let us start with learning outcomes of this module. Dear learners, the present module will make you acquainted with the concept of writ jurisdiction, principles for the application of writ jurisdiction, origin of the writ jurisdiction in England, early statutes and charters in India, writs under provisions of the Constitution of India, Article 32 and 226 of the Constitution of India, and last, types of writs. Dear friends, I would like to begin this module by quoting some lines from King Martin Luther as, "Injustice anywhere is a threat to justice everywhere." This means that if anywhere in this world any wrongful act is committed or injustice has been done to anybody, then it will be spread like a virus and can't be tolerated anywhere. Therefore, all the justice done will be spoiled and everyone else has to wonder what it would take for that same injustice to be done with them. Moreover, there arises a need to provide justice to all and remove the bias from the system. Hence, the concept of writs was introduced in common law to keep a judicial eye on the work of administration. The Constitution of India broadly provides for 5 kinds of prerogative writs: habeas corpus, certiorari, mandamus, quo warranto, and prohibition. In India, the rule of law is supreme and the judiciary has the right to interfere whenever there is a deviation from this supremacy. The judiciary shall ensure that all administrative actions comply with legal limits and consider administrative measures to assess whether the authority has exercised powers, the authority misused or exceeded its powers, the authority committed an error of law, the authority violated principles of impartiality of the judiciary, and the authority has violated the fundamental rights of individuals. The writ process was in its origin continental, but it gradually developed on English soil in the 12th century. The writ was a command of the king in writing to the sheriff addressed to the defendants to appear in the court within the specified period. It appears that while all writs were commands issued in the name of the crown, only the writs which had special relationship with the crown came to be known as prerogative writs. It was by this system that King's Court made royal justice supreme over the justice administered in other courts. The prerogative writs were issued only when some cause was shown as distinguished from the original or judicial writs, which were used for suits between party and party and which were issued as of course. All the prerogative writs were not discretionary, some of them were issued as a writ of right. Moving further, the next question is, what is a writ? Dear learners, the first question that arises while reading the writs is, what is a writ? The answer is that a writ is a formal written order issued by a government entity in the name of the sovereign. This government body is typically a court. A writ petition can be termed as a formal written order issued by a judicial authority that possesses the authority to do so. The meaning of the word writs means command in writing in the name of the court. It is a legal document issued by the court that orders a person or entity to perform a specific act or to cease performing a specific action or deed. In modern democracies, administrative officials have a lot of discretion. In the lack of clear rules, etc., the use of those powers frequently becomes subjective. Hence, the need for control of the discretionary power is essential to ensure that rule of law exists in all governmental actions. In modern democracies, administrative officials have a lot to discretion. In the lack of clear rules, etc., the use of those powers frequently becomes subjective. Safeguards of the fundamental rights and assurance of natural justice are the most important components of writ jurisdiction. A writ is a written official order issued by the court. The formal order may be in the form of a warrant, direction, command, order, etc. Fundamentally, a writ is a formal written order issued by anybody, executive or judicially, authorized to do so. In modern times, this body is generally judicial. Therefore, a writ can be understood as a formal written order issued by a court having authority to issue such an order. Orders, warrants, directions, summons, etc. are all essentially writs. A writ petition is an application filed before the competent court requesting it to issue a specific writ. Writs can only be issued by the High Court under Article 226 of Indian Constitution 1950 and the Supreme Court under Article 32 of the Indian Constitution 1950. The Indian Constitution has adopted the concept of prerogative writs from English common law. Writs were first used to describe a written command of the king. Differentiating between writs and order, it can be said that writs can be issued to provide extraordinary remedy, that is, in cases where the aggrieved person is seeking an extraordinary remedy, normally against an administrative action, whereas the order can be passed in any matter. There are 5 different types of writs provided under the law, whereas no such classification for orders has been made. Dear friends, it is very important to know about principles for the application of writ jurisdiction. The writ jurisdiction exercised by the Supreme Court under Article 32 of the Constitution of India and by the state high courts under Article 226 of the Constitution of India for the enforcement of fundamental rights is mandatory and not discretionary. But the writ jurisdiction of the state high courts for any other purpose is discretionary, whereby the high courts have the great responsibility of exercising this jurisdiction strictly by judicial consideration and well established principles. Sometimes courts abstain from hearing a writ petition by invoking the doctrine of forum non convenience, a discretionary power that allows courts to dismiss a case where another court is much better suited to hear the case. This dismissal does not prevent a plaintiff from refiling his or her case in the more appropriate forum. Writs are meant as prerogative remedies. Prerogative means a special right that somebody has. The 5 writs incorporated under Article 32 and 226 of the Constitution of India are known as prerogative writs in English law, because they originated in the king's prerogative power of superintendence over the due observance of law by his officer and tribunal. Such prerogative writs are extraordinary remedies. When ordinary legal remedies seem inadequate, in exceptional cases, writs are applied. Dear learners, the most important aspect of this module is the origin of writ jurisdiction. Let us discuss it. So, at first we will discuss the origin in England. The origin of writs took place in English judicial system. With the development of English law from folk courts moves to the formal courts of common law. The law of writs originated from the orders passed by the King's Bench in England. The writs was precisely a royal order which was issued under the royal seal. It used to be issued on a petition presented to the king in council for the exercise of extraordinary judicial powers in a particular matter. At the initial stage, the king's court consisted of barons and high ecclesiastical with legislative, judicial and administrative functions. However, with various phases of history, it took different names and forms, but the spirit of this extraordinary power remained almost the same. Though the development of common law courts in various forms had also been constant, the origin of the writ court had a specific reason. The jurisdiction of common law was more or less static. It did not recognize rights except those already prevalent and admitted by it. Similarly, common law courts worked under a prescribed procedure with many limitations on it. Its forms under which rights were to be enforced were fixed and limited. Thus, there had been several cases which did not fall under any of the fixed remedies, and so these cases remained beyond the jurisdiction of the common law courts. In such cases, these courts were powerless to grant relief. Thus, the deficiency of remedy or failure of the common law courts to grant relief in time became the cause, ground of petition to the king in council to exercise their extraordinary judicial powers. These petitions were heard and disposed of by or on behalf of King's Bench. A written order was issued in the name of the king called a writ, which was to act as a foundation for the subsequent proceedings. Originally, writs were intended to be issued only by the crown and in the interest of the crown. However, in due course of time, the writs became available to the ordinary citizens also. A prescribed fee was charged for these writs, and that is why the filing of a writ used to be called as purchase of a writ. These writs were used to establish royal supremacy also. This form of adjudication was called prerogative writs also. Moving further, next is early statutes and charters in India. The Regulating Act 1773. The origin of writs in India goes back to the Regulating Act 1773, under which a Supreme Court was established at Calcutta by a charter in 1774. A royal charter dated 26th March 1774 was issued by George III in pursuance of the Act of 1773, which established the Supreme Court at Calcutta. Its judges were given the same jurisdiction and authority as were exercised by the King's Bench in England. Clause 21 of the said charter authorized the Supreme Court of Calcutta for the first time in the history of India to issue prerogative writs of mandamus, certiorari and procedendo and error. But it gave rise to another question: the jurisdiction of the Supreme Court in matters of issuing writs was confined to these four types of writs only. It is well known that the Supreme Court issued a writ of habeas corpus, which is also a high prerogative writ. From where did the Supreme Court derive this authority and power to issue a writ of habeas corpus? Justice Das had pointed out that this power was enjoyed by the Supreme Court under clause 4 of the Charter of 1774, which conferred on the Chief Justice and the Peon Justices fairly and respectively such jurisdiction and authority as are Justices of the Court of King's Bench have and may lawfully exercise within England. Clause 4 therefore gave to the Supreme Court of Calcutta very wide powers as the courts of King's Bench enjoyed in England. A similar charter also established the Supreme Courts of Madras and Bombay with analogous provisions in 1801 and 1823 respectively. Letters of the patent were given to all three courts. Further, writs under Indian High Courts Act 1861 The Indian High Courts Act of 1861 empowered Her Majesty Queen Victoria to issue letters patent establishing the High Courts in the 3 presidency towns in place of the existing Supreme Court. The letters patent was issued in 1862, which abolished the 3 Supreme Courts and in their place established the High Courts of Judicature at Calcutta, Bombay and Madras. High Courts also established enjoyed all the powers which were there with the Supreme Courts replaced by these courts. Thus, the 3 presidency High Courts inherited the power to issue writs as successor to the Supreme Court. Other High Courts subsequently established did not have these powers because they were newly created and they could not inherit these powers as the presidential High Courts did. The special authority which was conferred by the Charter on the 3 presidential High Courts was not mentioned in the letters patent of the subsequent courts. However, the writ jurisdiction of these courts was limited to their original civil jurisdiction, which they enjoyed under section 45 of the Specific Relief Act of 1877. Under the above status of the law of writs, our country got independence and the Constitution of Free India came into force. The law of writs as inherited from the English colonial regime had a limited scope, but its effectiveness was time tested. Therefore, the constitutional forefathers decided to retain the concept as such in its nature, as a broad parameter, but its scope was enlarged by adding some new words to it and it was left open ended. This was essential also, keeping in view the hopes and aspirations of the people. The people had suffered the peril of the foreign yoke for the centuries and their faith and confidence in the new setup was bubbling with spontaneous feelings of freedom, wherein they dreamt of endless liberties. However, it was not to be allowed to go as a dream only, and to fulfill these hopes a vast scope of liberty, justice and equality was provided in the Constitution. The fundamental rights were incorporated in the Constitution of India, which fully ensured basic human liberties. To fructify these rights into actual liberties, a detailed legal provision was incorporated in the Constitution itself to safeguard these rights. Under Article 32, the enforceability of these rights was included as a fundamental right, and an almost parallel provision was provided under Article 226 as a constitutional right. To understand these two provisions in their true spirit and context, it would be desirable to first see them in their literal context. Dear students, now I would like to put light upon the constitutional provisions. Article 32 of the Constitution of India. Article 32 of the Constitution of India is the right to constitutional remedies enshrined under Part 3rd of the Constitution. The right to constitutional remedies was considered the heart and soul of the Constitution by Dr. B.R. Ambedkar. Article 32 makes the Supreme Court a protector and guarantor of the fundamental rights. Article 32 subclause 1 states that if any fundamental rights guaranteed under Part 3rd of the Constitution are violated by the government, then person has a right to move the Supreme Court for the enforcement of his or her fundamental rights. Article 32 subclause 2 gives power to Supreme Court to issue writs, orders or directions. It states that the Supreme Court can issue 5 types of writs: habeas corpus, mandamus, prohibition, quo warranto and certiorari for the enforcement of any fundamental rights given under Part 3rd of the Constitution. The power to issue writs is the original jurisdiction of the court. Article 32 subclause 3 states that Parliament by law can empower any of the courts with the local jurisdiction of India to issue writs, orders or directions guaranteed under Article 32 subclause 2. Article 32 subclause 4 states that rights given under Article 32 cannot be suspended except such suspension provided by the Constitution itself. Baba Saheb Bhim Rao Ambedkar called Article 32 is called the heart and soul of the Constitution because it gives rights to people to move the Supreme Court directly for enforcement of their fundamental rights. Article 32 is itself a fundamental right and it makes Article 32 the soul of the Constitution of India. According to the Supreme Court, Article 32 is the basic feature of the Constitution. It can't be amended even by way of amendment in the Constitution. Moving further, there is Article 226 of the Constitution of India. Article 226 is enshrined under Chapter 5 of the Constitution. It empowers the High Courts to issue certain writs. Article 226 gives discretionary power to the High Courts to issue directions, orders, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari. Article 226 is invoked not only for fundamental rights but also as a violation of other rights. Article 226 states that despite Article 32, the High Court has the power to issue direction, order or writs, including writs like the writs in nature of habeas corpus, mandamus, prohibition, certiorari to any person, authority, government or public official for enforcement of fundamental rights or any other right under its local jurisdiction. Dear learners, there is a difference between Article 32 and 226. How Article 32 is different from Article 226? Let us have a look. Article 32 gives power to the Supreme Court, whereas Article 226 gives power to the High Court. Article 32 is invoked for the enforcement of fundamental rights only, whereas Article 226 is invoked for the enforcement of fundamental rights as well as other legal rights. The power of the High Court under Article 226 is wider than the power of the Supreme Court under Article 32. Article 32 is itself a fundamental right, right to constitutional remedies, whereas Article 226 is not a fundamental right. Further, types of writs. The Indian Constitution provides 5 types of writs that can be issued by the courts. They are habeas corpus, mandamus, certiorari, prohibition and quo warranto. Dear friends, with this I would like to conclude the module by saying that even though we have fundamental rights that are enumerated in Indian Constitution, without Article 32 they can't be protected or enforced. Article 32 is regarded as the soul and heart of Indian Constitution and this article empowers the Supreme Court to issue certain writs for the enforcement of fundamental rights or whenever there is an infringement of fundamental rights. The Supreme Court is the actual protector of fundamental rights and Article 32 enhances its judicial power and writs are the finest remedy that prevents arbitrary actions which are contrary to the fundamental rights. However, Article 32 has some restrictions that through it Supreme Court can't issue writs in cases of violation of legal rights. Article 226 of the Constitution allows High Court not only enforce fundamental rights but the use of word other purposes, also allows the High Court to enforce legal rights as well. It is pertinent to note that the word persons also includes a company due to its juristic personality. Hence, a company can also invoke the jurisdiction of High Courts under Article 226 for the enforcement of its fundamental or legal rights. However, Certain fundamental rights such as the rights enshrined under Articles 15, 16 and 19 are only available to citizens. Hence, these fundamental rights are not available to the foreign company. A foreign company can only invoke writ jurisdiction of High Court under Article 226 for enforcement of its legal rights as well as fundamental rights that are available to non-citizens as well, such as in Articles 14, 20, 21, etc. Thank you very much, friends. We will see you in the next module.